We talked about the oral arguments in the Louisiana racial gerrymandering case before the High Court last week, but we'll get a constitutional scholar to weigh in to see if my review was on point. Perhaps the most jarring moment in the oral arguments was when Judge KGB, or KBJ if you prefer, Ketanji Brown Jackson, made this comparison, taking, in my view, the soft bigotry of low expectations to a new low.
A kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact,
blacks are disabled. They're tantamount to the disabled in terms of access to the voting system. The present-day manifestations of lack of equal access, she was a little hazy on the details there. If you're going to make an assertion like that, I think you need to make it with a concrete example of just what the hell you're talking about when you discuss access to vote. Where are blacks being denied access to vote or having to face hurdles that other races do not face in order to vote? Are there different early voting periods by race anywhere in the country? I'm unaware of that. Any other guidelines at any state level that suggests that people are being treated differently with respect to their franchise and their opportunities to exercise it based on their race? Yeah, I didn't get any details to support that assertion, which is just a wild statement to make, given no details. For more on this and other legal matters, please be joined by Professor Richard Epstein, the James Parker Hall Distinguished Service Professor and Emeritus of Law and Senior Lecturer at the University of Chicago. Professor Epstein, thanks for joining us. Appreciate it.
It's always a pleasure to join you. There's something afoot, I'm sure.
So what about the that racial gerrymandering case and to the extent you consume some or all of the oral arguments, where you think that the court is going to go in that case pertaining to the Voting Rights Act?
Well, I mean, I think virtually everybody has the same prediction, which is that the ability to use race as a factor in gerrymandering is going to be either curtailed or eliminated. The problem about doing all this stuff is the Equal Protection Clause gives you only the faintest guide as to what it is that's the nature of the wrong and what it is that's the nature of the remedy. And in fact, there are two issues at play on discretion. One is the weird districts that are created because of race, and the other is the weird districts that are created because of the Rucho's decision, which says that the courts will not supervise the way in which political forces influence the shape of these particular districts. And it turns out that if you have both of those things, it's a nightmare, because you can't get anything done. You get rid of one of them, what you do is you now increase the political ability of people to shut out anybody whom they want to do for political grounds. And that's also equally dangerous. But the idea that this is a question of access to voting as opposed to the way in which you manipulate the districts, that's crazy. As it was pointed out years ago in Shelby County, after the Civil Rights Act voting in 1965, black participation in the South in many cases is much higher than is white participation. And so you can't treat that as a kind of an exclusion situation. And as you mentioned, there's no differential laws that are around there which says that black people can't do this, and there's no law that's on the book which was passed with the effect of trying to create some form of discrimination. So I think the basic argument here is going to be, are they going to basically just get rid of the race thing because it's suspect and not the political configuration things? And if they do the first but not the second, remember, in a state like Illinois, if the Democrats are controlled, what they can do is they can make the districts largely Chicago and a little bit suburban and control all of them. If the Republicans are controlled, they'll keep all the Democratic districts in the city, and therefore the Republicans will control the rest of the state. And in a state with 18 electoral votes, you probably could switch 3 or 4, maybe even 5 seats one way or the other. So this is a really dynamic problem. I think that the court has talked itself into the hole when it decided to put its hands off of political redistricting. And I think the people who think that race is really important will say, look, you allow for political redistributing, we'll have a state which may have 25% black population, and it turns out we'll have no black representatives, even if you have 8 or 9 seats.
Yeah, but that was the point that Sotomayor was attempting to make. But of course, reality gives lie to that assertion, which is you have minority representatives in majority white districts, and vice versa, frankly. So I mean that the reality just belies what Sotomayor and KBJ were arguing, because like so many of these race hustling politicians on the left, they are pretending that America in 2025 is 1963 Selma.
It certainly is a problem. I mean, I think what you say is right, but here's the answer is not their answer. I dissociate myself with them, is that there's going to be a tendency to go in that direction. And so that what happens if you had a map, and this is the challenge, in which every district was 35% black and 65% white, you would probably have, if there were 10 districts, 1 black representative. And that has always been the problem, but this is an inherent problem. It turns out everybody ideally would love to see reapportionment take place, so that the more power that you have in the voting situation, the more representatives you have. But it's just impossible to achieve that, no matter what you do, particularly if you're going to have territorial districts. You can do it if you adopted the kind of system that they have in Israel and so forth, where what you do is you run slates statewide, and then as your percentage of the vote increases, what happens is your percentage of the Knesset or the state legislature or the Congress increases as well. The problem with that is legislators and Congress people, they perform constituent services. And if you just have a disconnected slate with no territorial controls whatsoever, it's going to lead to a world in which nobody knows whom to call in order to fix the local problem. That's why we prefer a local district. My own solution was the one that they had in Chicago many years ago. Do you remember Bernie Epstein?
Bernie Epstein, sure. Ran against Harold Washington, right?
Yeah, that's right. But before that, what we had is three-person districts. And Bernie Epstein could always win in Hyde Park because a third of the people in the city wanted him, or the district wanted. Well, if you have multi-districts of 3, then you will get greater minority representation. But that system was gotten rid of by the Democrats in large part because they knew that Bernie Epstein could win it. So I like that intermediate solution. There's nothing that precludes it from being used. But as you can see, it would be extremely difficult for one pointy-headed academic to tell everybody in 49 other states, hey, you better do it my way. So I think in effect that we are in a very bad situation. I would reconsider Rucho, which is the decision which says it's a political thicket. It is just crazy to make small adjustments that nobody cares about. This district has 1% more population than that district, and all of a sudden when we started looking at that, we thought, this is just terrible, we can't do it. And then when we have this massive gerrymandering taking place, we just turn a blind eye to it. The briefs that were written in Reshow by Nick Stephanopoulos and his crew told about the cracking and stacking situation and could propose kind of computer-like remedies to deal with it. And Chief Justice Roberts said, I read Cold Organ Green. That was the famous decision by Felix Frankfurt in 1946. And this is a political thicket. Frankfurt has said, I don't want to get involved at all. Brennan says we now have districts of equal size. We have equal size and no limits on the shape in which these districts can assume. You're going to get political monstrosity. In Shaw v. Reno, they say, we can take race into account, but not this far. And you think about this as a standard. You can't do this one, but we don't know what the next one's going to look like. If you have a kind of intermediate mushy rule, what you're going to do is get litigation in every state, because virtually every one of them will have intermediate solutions that may or may not meet the balancing test that Justice O'Connor liked in that case. So this is a genuine national crisis. And again, I would stress, Russo must go. Chief Justice Roberts must put on his thinking cap and say, this is the way I'm going to solve this problem, instead of taking it off and saying, if you guys want to do something corrupt, it's just fine with me.
But I mean, the Supreme Court has sort of promulgated best practices, contiguousness, compactness, respect for municipal boundaries. I mean, so there is,
but they've never enforced them.
I know. But I mean, but that is out there, right?
Yeah, no, and that's what I wanted to do. There is nothing which says that it has to be done by a committee. These are not laws. I mean, it's the interesting thing. It says the state legislature shall prescribe. And when they say that, it's not like saying there's a statute in which the governor has the veto or something of the sort. They really meant it to be an exclusively legislative function. One of the really difficult things about the Constitution is that it operates in so many other ways, that it just doesn't pass legislation. And when you look at a particular provision, it's something to tell you what the legislator can do, and the legislator can do lots of things that aren't legislation. Various kinds of vetoes and so forth, beginning the prosecution. And you have to be a close textualist to understand that the headings, legislative power, and judicial power, executive power, are basically broad approximations, but the Constitution has to wiggle so many things into various places that you can't fit it all that way. So all of the stuff restricting the ability of states to deal with contracts and so forth, they're all in Article 1. They couldn't figure out where else to put the darn thing. You're drafting a document that's more complex than any that's ever been attempted in the history of the world. You give yourself 6 months to do this kind of thing. You know what? You're going to make some complete hell with it. And they did. And so the large problem that you always have is how do you deal with it? Now, let me just mention one thing to you clearly, which most people don't know. If the original design of the Equal Protection Clause was part of the 14th Amendment, and way back in 1866 when they negotiated all this stuff, the deal was we will let all these things go through on condition that you don't require voting for black. That was the deal. So there is no technical ability to deal with voting under the Equal Protection Clause. That all comes up much later. None of it is originalist, because the original 14th Amendment was very heavily racist on all sorts of things in ways that are so astonishing that people today just don't want to believe in it. So, originalism is one of these very mixed stories. Sometimes you see originalism and you don't follow. Nobody follows originalism on the reading of the 14th Amendment, because what it does is to hold off for racial exclusion from voting. How do you like that, my friend?
Yeah, no, I mean, I hear that, but I mean, I want to get something else.
We are basically in a world in which the Equal Protection Clause dominates, and that's correct. I don't want to fight that. But what it is it doesn't give you sufficient tools to deal with it unless you have some standard of review on the shape of districts. And when Chief Justice Roberts said, I can't figure this stuff out, he opened the door to mayhem in Texas, in Illinois.
Yeah. I mean, it sort of strikes me almost like it would have to be some sort of like Potter Stewart standard. Like I know it when I see it. I know something that's been gerrymandered politically beyond the standards.
If you look at those stuff, there's a way in which you could basically count how many excess votes there are for somebody. So if you have a district which is 55% Republican and you work the state and now it becomes 80% Republican, what you're doing is you're saying, I'm going to take 25% of the votes elsewhere where they matter and put them into this state where they don't matter. And then it turns out there are computer-like techniques where you could try to revisit it if you're doing it. But the point is, if you're right when you say, we have contiguous, we have square districts, we have local boundaries. If you had a machine that you could put those things into, you could come up with pretty good answers.
Right.
What happens in Illinois is you have a 2-2 division, you flip a coin, right? And if the Democrats win, there are 3 more Democrat seats. And if the Republican wins, there are 3 more Republican seats. And I think that's much less stable and much less legitimate than having a machine which is not subject to bias run this. In New York, when they started to use the machines a couple of years ago, it produced much more desirable the votes than did the state legislature. They had an independent commission, which is the same thing. But if it's an independent commission, it can't be 3 from my side and 2 from your side. It has to be a bunch of technicians, academics, God forbid, computer guys who are doing it. And we just are not there today.
Before we run out of time, I wanted to get your view on these public safety issues that are before the courts and working their way up to the Supreme Court. Trump's use of the National Guard for federal law enforcement, like he's been stymied from deploying the National Guard that's stationed right now out in Will County to the Broadview ICE facility. Does he ultimately win that at the Supreme Court level?
No, he's going to get clobbered.
Why?
And he should get clobbered because what happens is you have a series of predicates as to what we've done, and they talk about invasions and relative inability to do work. Trump says, I'm the sole person in the world who can decide those questions, and my decisions are unreviewable. And what the court below said, that means you can declare anything. Let me give you another illustration. If these are rebellions and insurrections and so forth, January 6th is obviously an insurrection.
Well, he hasn't invoked the Insurrection Act, nor does he need to. Well, why does he need to invoke that?
Because he invokes other statutes which use exactly the same term. Every statute that he's talking about has the word invasion or rebellion or inability to do it. Well, and the way in which the...
But I mean, okay.
Is that the factual predicates have to be established independently. And the court said, well, give them deference, but we won't give it unreviewable. And deference is not going to be enough to save those decisions, given the careful record that was put together by the district court. And I think the Supreme Court will back him on such questions as, can you have a reduction in force that Congress can't do? The answer to that question is probably yes. But on all of these questions, the tariff question and so forth, the underlying factual predicates that he has, if they are unreviewable by any judicial body or anybody else, the president becomes, as his opponent says, a king. If you look at the Trade Act, nobody says you can invoke into the World Trade Organization by just simply making a declaration. You have to show some factual predicates.
Well, we'll separate the trade issue, the tariff issue for a second. I'm just talking about he activates the National Guard for the express purpose of backing federal law enforcement from enforcing federal laws. They're protecting a federal facility in the Broadview example. How is that beyond his authority?
Because what the statute says, he's only allowed to do that if the local people can't take control of the order. And it turns out even the Trump people said, the state facilities actually coordinated amongst themselves very well. Every kind of minor insurrection, quote unquote, that happened there was effectively controlled by the local police.
Well, except for the stand down order that was issued by Chicago police when ICE agents were under siege.
Well, look, at the moment you start doing that, then the calculus will change. But and this is, of course, one of the problems is that the biggest source of unrest is, in fact, the presence of ICE. Look, I am completely torn on these kinds of issues on the substantive stuff. But my view is you don't do midnight raids, taking people out of their beds for this kind of thing. That's reserved for people who are in acts of rebellion and throwing rocks and stones at it. And I think what's happened to ICE is it's lost too much of its legitimacy, because it's going after illegal aliens who are mom and pop, whose children have been here, who have nothing to do with any of the gangs and so forth. And so what's happened is there's a real crisis of legitimacy in this country. And, God knows I'm not a Joe Biden fan, as you understand. I thought he was disgraceful on this stuff. But I think Trump has gone too far, and I think he will lose all of the cases which say that there's going to be a proof of predicate before he can act.
Well, I mean, there may be a crisis in legitimacy in certain quarters, and with Clinton and Biden appointed judges, but that doesn't mean it's system-wide or
well, I mean,
nationally.
In this panel, I think that basically, I think there was a Trump judge, I think there was an Obama judge, and the early judge, she was, I don't know, way back there, no leader. Anyhow, the oldest judge in there, he's 86 years old and so forth. So she was appointed a much earlier time. Look, I mean, this is a very long, thorny kind of issue. The single most decisive question before the country today is the so-called unitary executive, which means that anything that's put into the executive branch, the president cannot be subject to review by anybody. And I would say, a minority of scholars believe that position. The majority of scholars don't. I'm actually writing a long discourse on that. And let me put it this way. The Constitution was dead silent on the scope of the definition of executive power. You go back and you read John Locke, the most dominant sort. He says we have to have a separate executive because he has to be on duty all the time, and the Parliament can go home, and the Congress can go home. That's it. And so the question that was not answered in the Constitution is who can remove the Secretary of State, the Secretary of Treasury, and the Secretary of War? And the Constitution is dead silent. It has a lot to do about appointment, nothing to do about removal. And that question, by and large, was resolved in favor of the president. And in a case called Myers, Justice Taft, as former president himself, made a huge mistake. And said that there is a local official, Postmaster Patrick, who's appointed with Senate confirmation. He said that he can be dismissed. And he's been appointed by a lower body, and then in fact he'd be protected. You don't want lower people to be governed by the same rule that you have your cabinet officers. These are not people who
Professor Epstein, you're cutting on us in a little bit here, but we're up against the clock anyway. But
I will say thank you.
Thank you so much. We appreciate it as always, Professor Richard Epstein. James Baker. Go ahead.
You should be executive.
Professor Epstein, thank you. James Parker Hall, Distinguished Service Professor, Emeritus of Law and Senior Lecturer at the University of Chicago, joined us on the Turnkey.pro answer line. Appreciate that. Well, that's interesting, his perspective on those issues dealing with the president's ability to aid and abet the enforcement of federal immigration law. We'll have to pick up that discussion tomorrow, among many others. Still haven't gotten to the Nancy Pelosi piece on J6 from last week either. So we have some unfinished business that we will tackle tomorrow. Thank you to everyone who called in, chimed in on the various discussions we had today, including, of course, most entertainingly, on the No Kings silliness over the weekend. Sound and fury signifying not much, as the bard might say. It is now 9 o'clock.